Salutations, respective viewers. This is George from Ireland. I'm continuing my series about criminal law, or English law, but looking at criminal particularly. English law would also be known as common law. Not all of the statutes would apply to the whole of the Commonwealth or to the Republic of Ireland or to the United States, but the core principles are shared by common law countries. So I'm going to look a little bit about sex crimes this time, sexual abuse, in particularly the Sexual Offences Act, the year 2000. Well, prior to that, somebody in a position of trust, such as a police officer, a nurse, a teacher, a dentist, or whatever, a stepfather, stepmother, this position of trust in relation to someone aged 16 and 17, if such a person had a consensual sexual liaison with that person, it was not a crime. It would have been a sacking offence in these jobs, but it would not have been a criminal offence. And now, since 2000, it has been a crime, even if the younger party, the 16 or 17-year-old, fully agrees. Obviously, below 16, it's a crime. Now, if the person was over the age of consent, wrongly believes that younger person, who's 13, 14, or 15, to actually be over 16, then that would be no case to answer. If someone who was, say, 15 had a liaison with someone who was over 18, and the older party really believed that 15-year-old in fact was over 16, then that wouldn't be a crime, because people don't always say police mercy or birth certificate before having some physical encounter. Well, I'm going to look at a fictitious case here of a teacher called Paul Connor, and any similarity to any person living or dead is entirely coincidental. So imagine that several of his pupils said that he had molested them, he'd sexually abused them when they're under the age of consent. And he's assisted by someone called Simon Fortescue, again, a completely fictional character. So Paul and Simon go on trial. They plead guilty to these heinous offences, and given the severity of the offences that were committed against very young children, these two paedophiles are sent down for their prolific offending. The judge awards them 20 years apiece. They're held in a secure unit for their own protection, away from the other jailbirds, because they might be harmed by the other prisoners. People might be putting things in their food or whatever, physically attacking them, have to be kept in a special place, a special unit. After many years, they're known as nonces in prison. They might be sent to an open prison, Ford Open Prison, for example. The attraction of this for the government is it's very cheap to run, whereas the gates are not even locked. You can get out very easily. But why would you escape? 20 years, you wouldn't serve 20 years, you might serve 15. For the last couple of years, you might be in the open prison. Very relaxed regime, sports ground, they'll let you out on parole quite a lot. So why would you escape? You'd be stupid to escape. Just serve out the last 2 years or so and then be out on licence. But if you do run away from the open prison, which is quite easy to do, and you get caught, you're going back to a real prison. So category A are the most dangerous criminals. There's category B and the category C. And below even that, there's an open prison. So non-violent offenders, fraudsters, will go to a real prison for the first few weeks and then to an open prison usually, because they're not a menace to the public. So coming on to military law. Now, the armed forces have their own system of justice, which is outside the scope of this course, but I shall touch on it. Well, so just speaking tangentially about it, the army has its own judicial system, its own legal service indeed, its own barristers and solicitors who work for it, its own judge advocate, who's at the apex of the system. And unless the system is very heinous, such as murder, well, those would be tried in the civilian courts. For the most part, the army deals with these matters itself, and the army will award its own sort of pena. It's got its own prison in Colchester. But I think there's also shared with the Royal Navy and the Royal Air Force, and there used to be more of these prisons around. So soldiers go away for the weekend to get drunk and get into a fight, not an uncommon occurrence, will be arrested by the police, the civilian police. The police will usually hand them over to the Royal Military Police, who'll bring the suspect back to his or her unit. The military may prosecute them according to their own procedures. Now, for administrative offences, trifling things, an officer can simply award a punishment on the spot without any judicial process. Otherwise, they do have some more informal hearings, have to take their hat off for that for some reason. And they're then told to plead guilty or plead not guilty, the plea could be accepted or not. And there's some very brief quasi-judicial process. So that is that. Right, absolute discharge. Back to the civilian courts. Courts can very occasionally grant someone an absolute discharge. This means the charges are set aside. So let's examine another fictitious case. Well, here's a fictive character, Xenophon, and he finds some old ammunition in the forest. He decides to pick it up and bring it to the police station to hand it in. Xenophon is stopped on the way and he's searched. He's arrested and the bullets are found on him. He's charged with unlawful possession of ammunition. Well, it's not legally his, and suppose it's the sort of ammunition you can even get a license for these days. He doesn't have a license. So yes, there's the actus reus, the guilty act, the mens rea. I mean, he knew what he was doing, he picked it up, knowing it was illegal. Another point is, ignorance of the law is no defence under law. Saying I didn't know actually doesn't wash. Might seem unfair, but there we are. So in the scenario I just adumbrated, Xenophon would most probably be granted an absolute discharge by the court. So that's that. Although strictly speaking, he is guilty, he'd be wiped. So talking about the Crown Prosecution Service, the CPS, the top of that system there is the Director of Public Prosecutions. The CPS handles prosecutions, and they have to examine whether there's a good chance of someone being found guilty or not. It'd be a waste of money and time to proceed to court with a case when there is a flimsy chance of securing conviction. There's got to be some reasonably convincing evidence. The CPS has to ask itself, is it in the public interest to prosecute? In the United States, this function is partly discharged by a grand jury, and we used to have those in England and Wales, as we did in Ireland. Anyway, the CPS can decide noli prosequi, do not prosecute, issue that order. There certainly was a way that the Attorney General could intervene. He's like the government's barrister, although he's elected an MP, or it could be a she, hasn't been a woman so far. And he was able to intervene. The trouble is, that was like political interference. So I don't think this happened for a long time. Sometimes charges are ordered to lie on file. This means that a person is not prosecuted in relation to the charges, but neither of the charges dropped. They could be activated later on, especially if new evidence comes to light. The CPS could revive these charges at any later date and might go to trial if they reason that there's a good prospect of a conviction. Noli prosequi decisions have sometimes been politicised. In 2006, corruption charges relating to payments to the Saudi Arabian government for an arms deal were dropped. This is 2006, sorry. And this is because it would have been detrimental to the United Kingdom's relationship with Saudi Arabia. And Tony Blair, who was the Prime Minister at that time, he defended this decision. So we have to look at the totality of the consequences of this. And somebody said that was unacceptable, that was blatant political interference. What happened to the independence of the judiciary? Okay, it was with the CPS, not the courts as such. But even so, the justice was not being served. Whatever had happened to fiat justitia ruat caelum. There we are. So it's fascinating to think where there's the crossover between politics and law. Should they cross over at any point? Is it possible to completely separate them? Perhaps it's not. Politicized seems to be a sordid word. I suppose it doesn't have to be, as though things that judicial are purer, higher. People sometimes complain about judicial activism, particularly in the United States, that a judge is advancing his own political agenda and misusing the courtroom for partisan political ends rather than being neutral, which is a tricky one. The thing is, there's a bit of an elite consensus amongst the judiciary against things like the death penalty and against torture. I know they're illegal, but there were cases where a government abroad tortured whoever who gave information about a terrorist organisation, which was handed to a British court. Was the British court able to consider that evidence or not? And the answer was no. It was too strict. Some people say, well, come on, don't be ridiculous. We've got to consider our people's lives. And yes, torture is unpalatable, but it should be a lower priority than safeguarding your own citizens. Face up to the repercussions of being on your moral high horse about this one. Let's look at private prosecutions. I can't think the last time this happened. Well, the CPS may choose not to prosecute someone. A person may then take out a private prosecution, which he may fund himself. These are highly unusual. The CPS, nevertheless, has the right to intervene and halt the prosecution. Look at the case of Stephen Lawrence, murdered in 1993, if memory serves. A young black man who was murdered in London, an area called Eltham, if I got that right. He was 18 years old. He was subjected to a bestial and completely unprovoked attack by several white boys, about 8 whites, set on him, stabbed to death on the street in the immediate presence of his friend Dwayne Brooks. So the police arrested 8 suspects, blah, blah, blah. there were some eyewitnesses, but it wasn't quite convincing. No DNA, no fingerprints. So that was that. They were not going to be charged. The Lawrence family decided they wanted to go forward with a private prosecution. The CPS warned them there was insufficient evidence to warrant such a prosecution, which is why they decided not to go ahead. Nevertheless, the Lawrence family pressed ahead with the prosecution and ended at a not guilty verdict, as they had been warned. Now, I'm afraid if I was a juror, I would have arrived at the same conclusion. It's become a cause célèbre for liberal and left-wing people. The murder of this boy was monstrous. He's stabbed to death in broad daylight, done absolutely nothing wrong at all. And he'd been verbally abused with racist insults as his assailants were stabbing him. The other reason it's controversial is his friend Dwayne Brooks was found by the police right afterwards, highly agitated, as you can imagine. He'd seen his friend stabbed to death right in front of him. He'd been grabbed by the whites and he'd wrestled free and run off. He'd come within an inch of being stabbed to death himself. So as you can imagine, was very discomposed and dismayed. And the police initially treated him as a suspect. But it was a very confused situation, and someone who's there at the scene might have been the one who actually killed her. They didn't know, they had to piece it all together. Obviously eliminated. There's absolutely no suggestion that he was anything other than an innocent victim too. So the people in the Lawrence case were acquitted, and then it dragged on, and then supposedly the evidence was messed up, the whole investigation was bungled, it was going to be racist. There was the Macpherson inquiry. This retired judge said there was institutional racism in the police. I think it's bunker myself. Anyway, the law was changed to allow second prosecutions. Previously, there was a double jeopardy rule. Someone acquitted, like Jamie A. Court, for instance, of the murder of Stephen Lawrence could never be tried for the murder of Stephen Lawrence again, because then an acquittal was not once and for all. And then you're never really out of the woods, even if you're acquitted. And the prosecution, the police got to get it right. They can't be half-hearted about prosecution. That's why the CPS don't do it now. It's possible something could emerge in future, and then we could have a good prosecution. So the law was changed, and several years later, some of the suspects were prosecuted again, 4 of them, who were all found guilty of murder. They got light sentences because they could only be prosecuted as the minors they were at the time. I call them boys. They were all under 18 at the time of the murder. One was only 14 at the time of the slaying. So they couldn't get the full tariff that an adult would get for homicide. So that was the Stephen Lawrence case. Well, we could go on and on about it all day. Obviously, hundreds of murders every year in the United Kingdom, and dozens of them are unsolved. But this one seems to be more famous than anything else. Some people felt, well, it was just put a human face on the whole problem of racism. It just is typified a wider malaise in British society, where the police didn't have cordial relations with the black community, but the situation's improved very considerably since that time. So the murder of Mr. Lawrence, 1993, and then the Macpherson inquiry in 1999, if memory serves. So that's that. I was against changing the double jeopardy rule. They say hard cases make bad law. Okay, so he's murdered, nobody's ever caught for it, which is terrible, but we cannot guarantee people are going to get caught, and we cannot convict people just to satiate public opinion. That'd be like a lynch mob. Did these guys kill him? Probably. Probably is never good enough for a conviction, particularly for murder. Even the Lawrence's family-owned solicitor, Imran Khan, not the Prime Minister of Pakistan, the solicitor Imran Khan, he said that the suspects in the Lawrence case, couldn't get a fair trial and shouldn't be charged a second time. There we are.